Dear friends, welcome to Legal Matters by Sai Babu Sunkara. Recently, there was a good judgment given by Justice Lav Nageshwar Rao in the case of Section 306 of the IPC. So it is nothing but abetment to commit suicide. According to Section 306 of the Indian Penal Code, if any person commits suicide, whoever abets the commission of such suicide, if proved, shall be punished up to 10 years or with fine or with both. All these things this section will say. But it is highly difficult to prove the ingredients of Section 306 IPC. The first point is there should be proximate reason. The time also should be proximate. So the time of incident and the time of suicide, they should correlate. Otherwise, it becomes very difficult. Second is the thinking capacity or the mental attitude of the deceased person also. If he is a weak-minded person, if he commits suicide, then the court will not come to his rescue. So the circumstances should be such that they force him or they should drive him to commit the suicide. Then only this will be proved. Otherwise, it will be very difficult to prove the case. Now, while disposing the case of Rajesh versus State of Haryana, AIR 2019, you can see it in AIR SC 478 page number. In this case, the Supreme Court held that, so in order to prove the abetment or in order to establish the abetment to commit suicide, it should be so close, so proximate that there is no other go for the deceased except to commit suicide. The force should be like that. Simply mere uttering of words or uttering of words particularly in a fit of anger or omission without any intention. So they cannot be the cause, they cannot be termed as the instigation or abetment to commit suicide. This was the legal point in this particular case. So if you go to the details of the case, it will be easy for you to appreciate. Here, the deceased person, of course, Rajesh is the brother-in-law of the deceased person. Rajesh is the appellant in this case. Rajesh versus State of Haryana. Now, the deceased, name of the deceased, Mr. Arvind. This Arvind was married to Manju in the year 2000. On 7/11/2000, their marriage was performed. Of course, things were not that good. So, in the of course, Manju alleged dowry harassment. So some panchayat was also held in 2001. So since there was allegation of the so-called dowry harassment or additional dowry harassment, so his father-in-law, Mr. Lakshmi Narayan, brother-in-law, that is the appellant, Mr. Rajesh, and sister-in-law, Mrs. Indira, all of them, they threatened Arvind that they will file or they will implicate his family members in false cases. And they held panchayat also. I think in the year 2001, they held a panchayat. So during the panchayat also, there was an attempt to assault him. So aggrieved by all these negative incidents, unable to bear the brunt, and I think in 2001 itself, Mr. Rajesh, who is a brother-in-law, he tried to assault him. So unable to bear all these things, he committed suicide by taking some tablets, that is sulfas tablets on 23/2/2002. So please remember, the marriage took place in the year 2000, 7/11/2000. So the incident of dowry harassment and also the panchayat, all of them took place in 2001. And ultimately, he committed suicide on 23/2/2002. Fine, okay, he committed suicide, nobody can do anything. But he committed suicide on 23/2. On 1/3/2002, that is almost 10 days later or 1 week later, father of Arvind, Mr. Bhagat Singh, Bharat Singh, he opened the room of the so-called Arvind to sprinkle Ganga Jal, and at that time they found the note which is deemed as the suicide note. In this suicide note, he has categorically stated that his father-in-law, brother-in-law, that is opponent, and sister-in-law, they threatened him with false cases, that they would foist his family members in false cases, number one. Number two, an attempt was made to assault him during the panchayat held in 2001, and his brother-in-law also assaulted him. So in such cases, in such circumstances, it is not good to live. Therefore, he wanted to commit suicide. He committed suicide. So this was given as a report to the police station. Of course, the police they have registered a case under 306 IPC read with 34, and also they have added section 107 IPC, that is abetment or instigation. We can say instigation. So all these sections were there. They were arrested, sent for remand. The trial court gave conviction of 3 years to all the three. Of course, the matter went to the High Court in appeal. In the appeal, only this Rajesh was convicted, and the conviction against the other two, that is Indira and Lakshmana, they were set up. This man's 3 years period has been extended to 5 years. Now, agreed by the order, now they have come in for a revision before the Honorable Supreme Court of India, wherein Justice Nageswara Rao stated that the opinion, right? Their opinion is, we are of opinion that the evidence on record does not warrant conviction under section 306 IPC, because no proximity between the panchayat held in September 2001 and the suicide by Arvind on 23/2002. That means after 1 year he committed suicide. And also incident of slapping by the so-called Rajesh in 2001 cannot be whole and sole ground to hold him responsible for the instigating of the deceased to commit suicide. So actually all the allegations are similar. Therefore, the trial court should have convicted all the three, or should have acquitted all the three. Instead of that, they have acquitted, the High Court has acquitted two persons, that is Indira and Lakshmana, and convicted this Rajesh, and which is not correct. The High Court should not have convicted him also. So therefore, the appeal is allowed, and the so-called conviction is set aside, and the bonds are removed. So this is a beautiful case law negating section 306 IPC. So to prove 306 IPC, definitely the circumstances should be so proximate, so close, that the person has no other go except to commit suicide. That should be proved. If that is not proved, as advocates, we can definitely argue and say that this is a foisted case against our client, and you can come out successfully. Friends, you can cite this case law because it's a case law given by the Supreme Court, Rajesh versus State of Haryana 2019, and you will be benefited very much. Thank you very much.